Ghanatube so it was your former for snowy my science so atena sibium made some ahodo etwegum the four corners of Ghana bro na intem personal senior matnas no mede be wakotie ensem bia ekoso ewo omani na eba na busan format so e amamo.
Stays on the matters of law still. This time around, that's coming up next. The Attorney General, as Dr. Dominic Akuritinga Yene says, the case filed by the former Chief Justice, Torkornoo, at the High Court raises questions of interpretation, which can only be resolved by the Supreme Court of the Republic of Ghana. That is what the Attorney General is saying right now. And for that matter, he is headed to the Supreme Court for that particular purpose. Now, let's just refresh our minds. Exactly what are these reliefs that the former Chief Justice is seeking in this application that we ran through last week? And our senior legal affairs correspondent, Joseph Akable, is going to be joining us shortly. He's been combing through this latest move by the Attorney General to the Supreme Court. These are some of the reliefs that the former Chief Justice seeking: a declaration that the jurisdiction to hear a petition for the removal of a justice of the Superior Court from office lies with a body properly constituted under Article 1464 of the 1992 Constitution. She wants a declaration that the warrant of removal executed by the President, dated 1st September 2025, purporting to remove the applicant hearing from both the office of the Chief Justice and the office of a Justice of the Superior Court of Judicature, is unlawful, null, void, and of no effect. So what exactly is the Attorney General now seeking at the Supreme Court? Joseph Akable is a senior legal affairs correspondent, joining me on Zoom right now. Joseph, now you've seen the exact questions that the Attorney General is asking of the Supreme Court. What exactly is it all about?
So, Alfred, I mean, the first point to make is that, you know, the Chief Judicial Review action at the High Court asking the High Court to push the warrant of removal executed by...
Okay, Joseph, can you hear me? Can you hear me?
Yes, I can hear you.
Perfect. I lost you briefly. If you make that point again as to exactly what the Attorney General is asking of the Supreme Court right now.
I was making a point that at the other time you made reference to the warrant that was signed by His Excellency the President, and in that warrant you recall the President had said that he was removing her from office as a Chief Justice and Justice of the Supreme Court. Now that is what the Chief Justice, the former Chief Justice, is at the High Court seeking to set that warrant aside, because she holds the view that the petition was sent for her removal as Chief Justice, not as a Justice of the Supreme Court. Now what the Attorney General has done is to file two processes. The first process is to respond directly to the concerns that are being raised at the High Court, and that process is telling the High Court simply that what the President did in the warrant was simply to apply the law as it is, and as has been explained in various decisions of the court. And so the AG first takes the view that the President is right, that her removal as Chief Justice automatically results in a removal as a Justice of the Supreme Court as well. Then the second process is a request to the High Court. It's what constitutional theorists refer to as the referral jurisdiction of the Supreme Court, an opportunity for the High Court to be asked that the case that has been put before you, it raises questions of interpretation, and so do not deal with the matter, hold on and refer the matter to the Supreme Court for interpretation. And so that is the second process that the Attorney General has filed at the High Court, and they ask the court to refer three questions to the Supreme Court for interpretation. The first is whether a person may retain his or a previous judicial office, if any, upon the appointment to the office of the Chief Justice. A very important question, because they want to determine her status when she was appointed as a Chief Justice, because remind you, she was on the Supreme Court bench before she was appointed as Chief Justice. The second question is whether the Chief Justice's membership of the Superior Court of Judicature is ex officio to the office of Chief Justice. Again, we know that the Chief Justice, once you are appointed Chief Justice, you become automatically a member of all the Superior Courts. So the Court of Appeal, the High Court, the Supreme Court. And so the question that is being asked is that, does she acquire that membership of those courts by virtue of her simple appointment as a Supreme Court, as a Chief Justice, or is that not the case? And the final question that they are asking to be referred to the Supreme Court is whether a person may retain his or a membership of the Superior Court of Judicature upon removal from the office of the Chief Justice, which is basically at the center of the controversy that this particular legal case has generated so far.
Right from this moment, there's a decision by the Attorney General. How are the next steps going to be like after this particular question or these questions the Attorney General is asking of the Supreme Court? What happens next?
It would have to be fixed. And what is unclear at this stage, and potentially because of the two processes that have been filed, there is the possibility that the court may consider this notice for the prayer for the reference of the stated questions to the Supreme Court. And so the court would have to definitely fix a date to hear these two matters that have been put before it in terms of the judicial review application by the former Chief Justice and also the request by the Attorney General's office for the referral to be done to the Supreme Court. And so that would have to be argued at the High Court. And so the High Court can take a decision that, well, we do not think that we should refer the matter to the Supreme Court. Then it will have to answer the question of whether or not the case that has been filed by the Chief Justice leads it to the conclusion that the warrant should be set aside or the warrant should not be set aside. The court could alternatively also come to the conclusion that, well, as far as it is concerned, it raises questions of interpretation, and so these questions should be referred to the Supreme Court for interpretation. And this such requests are not new. We've seen it happen a number of times in various cases in times past.
Right, and then we're going to follow it every step of the way, and so we'll update our viewers as the days go by on this. I do appreciate you. Thank you so much for this here on Ghana Tonight. And these are the questions that Joseph Akablade, our senior legal affairs correspondent, references that the Attorney General is asking of the Supreme Court. Question number one that the Supreme Court should answer: whether a person may retain his or her previous judicial office, if any, upon appointment to the office of the Chief Justice. The second question we're going to put on the screen right now: whether the Chief Justice's membership of the Superior Court of Judicature is ex officio to the office of the Chief Justice. And three, whether a person may retain his or her membership of the Superior Court of Judicature upon removal from the office of the Chief Justice. The Attorney General is of the view, Lawyer Martin Kpebu, I know you're still with me. The Attorney General is of the view that these matters that are within the former Chief Justice's application and the relief she's seeking for this judicial review borders on interpretation, so he's headed to the Supreme Court for interpretation because that is within the jurisdiction of the Supreme Court. Will this move by the Attorney General bring the needed clarity and finality to this matter?
In terms of finality, yes, finality, no doubt, because then that would be the hopefully, but we can never be sure. Hopefully, the final forum for the Chief Justice to litigate this matter, because there comes a time when litigation must stop. But when it's in terms of clarity, I don't think it adds much. When you read the current cases, it's already clear that, look, when a person is removed as Chief Justice, by implication, that person loses his or her office as a Justice of the Supreme Court. Justice Modibo Okran, one of the Supreme Court justices in the Ejechum case, answered it more directly. That's the language he used. He says, when a person loses his or her office as a Justice of the, as a Chief Justice, that person by implication loses his office, his or her office as a Justice of the Supreme Court. And Modibo Okran didn't just pull that like from a rabbit's, like a rabbit from a hat. No, it wasn't magic. It wasn't magic at all. It's because the plaintiff, Frank J. Chum, through his lawyers, Kofi Asante and Nana Bedietu Asante, that's Asante Bedietu, that's the executive secretary to President Kufuor, had argued it on Saturday. I read it. Maybe we can read it briefly again. It was the plaintiff and the lawyers who argued that point before the Supreme Court answered for them. So for me, it has always been clear, when you engage in certain conducts as a Chief Justice, those conducts can also be contrary to your ethics as a Supreme Court judge. That's what that ban said. I read it on Saturday. I still remember the page 775. So 774 to 775. You find it there. Justice Dateban said certain conducts of a Chief Justice, okay, which are contrary to law, are also conducts of a Supreme Court judge contrary to law. So once that happens, when they are removing that person as a Chief Justice, that person is ipso facto removed as a Supreme Court judge. You don't need a new process. No. So let's come back to the things that are alleged to happen in this case. I like the way Mr. Okansi on Saturday, you asked one of our panelists. If you look at Article 128, that requires that a Supreme Court judge should have moral, should not suffer moral turpitude, etc., should have high integrity, etc. The things that have been proven against Chief Justice Torkornoo, are they things that a Supreme Court judge will be allowed to do and stay in office? Are they things that a Supreme Court judge will be allowed to do and stay in office? So let's be specific. That matter of signing for per diem and giving to the daughter $10,000, which even today is at least about 120, at least 12. I know now the CD dollar ratio there is going to 12, 13, right? Even if we put it at 12, that's 120,000. Even if we put it at the lowest, when this government came, the CD regained its strength, that's the dollar depreciated. So at a point, we're doing about 10.5. Even if we did 10.5, that would be 105,000. That's a lot of money for per diem, which is contrary to Article 71.
And it's one that we'll keep an eye on as well and see how things play out. Joseph Akablay, Lord Edwasari, they're heavy on this matter as it plays out in court. So stay with us here on TV3 and across all media journal platforms. We'll give you a lot more updates on this in the coming days. This
and some about for comments, comment section. I can kindly na ediamon. Answer na meso must make Ghanatube so in Sambia Ecoso ewo on my no unsa ebeka subscribe na hit the notification bell no for quick updates. See you there, Macau.